I want to thank you all for coming today. My name is John.Mariner. I'm an estate planner with 28 years experience in estate planning and trust work. I've personally delivered a little over 6,500 trusts in the last 28 years. We also provide services like this, classes for the community so that they can understand and have options for their estate planning needs. We're going to talk about wills and trusts and joint tenancy and community property, all the things that normally become part of the activity when you are thinking about how best to protect yourself and your families. Over the last number of years, our legal group produces over 200 trusts a month. So we are not the teeny-weeny trust company that just is here to sell you life insurance or something like that. We're here today to answer your questions. So whether we're talking about wills or trusts or joint tenancy or community property, all the stuff we talk about when we talk about estate planning, we're really only talking about one word. And if you know this word, you'll know more than all your friends know about estate planning. And that word is title. Title. You and I hold title to all the things that are ours, and we can prove it. And so this morning as I talk to you, we're going to talk about two different things. One of the things that you'll always have in mind is your pile on the table. In your pile on the table are all the things that you hold title to. We're also going to use a scenario which is pretty typical among most clients. This could be a married couple or it could be a single person. They have 3 children. One of their children has 3 children, the other has 2, the third doesn't have any. And all they want to do when they pass away is to make sure that their assets are equally divided among their heirs. It's a pretty simple scenario, it's pretty common. But you hold title to all the things that are yours and you can prove it. So as you envision your pile on the table, most people have a checking account in that pile. That's pretty common. The deed to your house is in that pile. And some folks say, well, I'm still making payments on my house. No, you're on the deed, and the deed determines title. The deed is all powerful. When you have an annuity, you have a contract number, you have a savings account number, even a safety deposit box key number. It means that you hold title. The reason why I can't go down to the bank and take money out of your checking account isn't because I'm not on the signature card. That's what people are told. That's not the real reason. The real reason is I don't hold title, and you do. Now you can give me title. You can take those pieces of paper that the bank prints up for us, that is our name and our address and our account number, and you could write John.Mariner, $10, sign that check, I'll take it to the bank. The bank legally looks at that check and says, we know this is a real check, we printed it. This is a real client with a real account number. We even have their signature on file, and there is $10 in that account. What are they going to do? They're going to give me the $10 and they take the check. So what have we done? We've transferred title. That's the way we conduct business all over the world. If I'm a hog farmer and you're a grain farmer and I want to trade you some of my hogs for grain, how can I do that if I can't prove that I own the hogs? Now, why am I bothering you with this little story? Because it is the heart of everything we do in estate planning. In this scenario, what we need to understand is that a will cannot transfer the title of our assets to our loved ones when we die. It's not designed to do that. A will is a wish list that says, this is where I want my money to go after it goes through probate. Because you see, a will is subject to probate law, and whether we die with a will or not, we're going to be subject to probate law. Now, before we continue, let's understand, a will is not a bad thing at all. And it's a good thing if people have a will, because you've decided who's going to get your money, you've decided who's going to speak for you. Those are good decisions. You've started to do some very serious estate planning. But we're going to talk today about doing estate planning, not estate guessing. We don't want to say, well, I think this is going to happen. This might happen. I'm not really sure. By the time we end today, you'll know what you want to do to plan your estate. So, a will can't transfer the title of your assets. It's not designed to do that. But a trust is not subject to probate law. A trust is subject to trust law. And under trust law, you can do a lot of things that you cannot do under a will. So, what is probate? There's a lot of confusion about what is or isn't this process that everybody's heard about. And that's not the client's fault, by the way. Less than 1% of all the attorneys in this country have any trust law training. In fact, if you and I went to law school today, we'd be trained in probate law. We would not be trained in trust law. And we'd make about 20 to 30% of our lifetime income taking people through this process. So you and I have a 99% chance that in good faith, we're going to go into the office of a qualified attorney and we're going to ask them, you know, I've got some children. I'd like to have no problems for them. I kind of like to make sure that my assets are transferred to them in a judicious way, a fair way. Do you think I need a will or a trust? They'll say, well, are you worth $10 million? I mean, trusts are only for rich people, right? Everybody knows that. So I can write you a will, and your will will say if you die, everything goes to your spouse. If your spouse passes away, their will will say everything goes to you. When both of you pass away, it'll just say it goes to your children, a third, a third, and a third. Let's go ahead and get started. I tell clients, you and I have a plumbing problem, and we've gone to an electrician. He's a nice guy. He's got a truck full of tools. He's certainly an honest guy, but he's not trained in taking care of our plumbing problem. You and I have a probate problem. And most of the time, we're going to be going to an attorney that makes his living in probate court. So you're kind of letting the fox in the hen house when you go to someone and say, how can I avoid these problems? And the first problem is the understanding of what probate is and what it isn't. When you and I pass away, they're going to ask our estate, our pile on the table, 2 questions. The first question they're going to ask is, we want to know who holds what? Title. Who holds title to all this stuff that you want to give to your children when you die? Because, you know, we can't have you giving away stuff that's not yours, which is a stupid statement when you think about it. We've held title, and many of my clients have held title to their assets for decades. But all of a sudden we pass away, and whether it's the state of Arizona, Maine, Oregon, Washington, they freeze our assets, nobody gets anything until the court process determines that you really owned what you said you owned the day before you died. As weird as that sounds. Nobody questioned that you and I held title before we died, that we could sell our house, rent our house, deposit money, withdraw money, change banks, change brokers, buy an annuity. We could do anything we wanted to with our own money. But then we pass away and, oh no, everything's frozen because we need to make sure, and we're going to do accounting of everything that's in your pile on the table. That's the first thing. The second thing is a little bit more upsetting, and that is they want to know how much. How much is it worth? I can tell you as an estate planner, I really don't need to know how much money you have. We don't ask clients how much money they have because we don't charge clients according to how much money they have. But most individuals who are looking for this information are trying to find out how much money you have so they can charge you for services rendered according to how much money you have. We think that that's a problem. So if people want to interrogate you as you go to get services like this, I would be very careful and cautious to just give a stranger all of the information about checking accounts, savings accounts, brokerage accounts, money market accounts, CDs, life insurance, annuities. I'd be very careful about that. In today's world of identity theft, it's not a good thing. But you see, the probate court, they need to know how much you're worth because they don't know how much to charge you. Right now in Arizona, when you and I pass away, probate runs about 4 to 11% of your total pile on the table. And it takes a minimum of 6 months to upwards of 2 years to get out of probate. Now, I didn't say if you're a millionaire, you're going to take 2 years to get out of probate. And if you're regular folks, then it's only going to take you 6 months. That's one of the fallacies that's been perpetuated for many, many years among probate attorneys and the public at large. We've been told and led to believe that there's a grand chart in the sky, and that when we pass away, if you look at our pile on the table, remember that includes your house or the equity in your house. So if you're worth maybe $250,000 total when you die, then you only pay 0.5% in probate fees. But if you're worth $400,000, you'll pay 2%. And man, if you're worth $500,000 with your house and other assets, you're going to pay 4 or 5%. And if you're worth $1 million, man, you're going to be up in the 10 to 12%. There is no such chart in the sky. Please understand it's whatever the market will bear. I had a dear friend of mine several years ago. His parents were millionaires. They were worth about $3 million. That's a lot of money. It's much more money than most of my clients had. They had a dear friend who was a probate attorney. He said, don't worry about a thing, I'll write your will. And he did. They both passed away. They got out of probate in 3 months, and it cost the estate 3%. What a deal. Let's think about that for a minute. What's 3% of $3 million? $90,000. What did the lawyer do that was worth 90 grand to take your stuff and give it to your kids? It makes no sense. Right around the same time, I had a dear friend of mine, he lost his mom. His dad had passed away years before. She was a great lady. She lived in Sun City West, little tiny townhouse, not really much bigger than this room. Hardworking, blue-collar, honest lady, and she passed away. Her entire estate, her entire pile on the table, was probably worth half what your houses are worth. 2 years later, she was still in probate court, and her estate had already paid over 10% in probate fees. Please don't let anybody tell you you don't need to worry about probate because you're not a millionaire. It simply is not true. Now, what's the qualifier? The qualifier is really simple. If you take everything you own and if you pile it on the table, if that pile is worth $75,000 in cash, you will be subject to probate in Arizona. Not $300,000, not $600,000, not $1.2 million, not $3 million, not $5 million. $75,000 is the Arizona probate limit. In fact, until about 30 months ago, it was $50,000. Now, we have a bunch of wonderful folks. They come here to Arizona. Sometimes they go back and forth. We love them. They enrich Arizona. We call them snowbirds. And many of those folks decide they're going to stay here for good because we've got so much to offer. They come to Arizona and they say, those dirty dogs in Arizona, $75,000? What a ripoff. I never heard about this back home. Please understand that Arizona has one of the highest probate limits in the entire country. In more than 2/3 of the states, the probate limit is $20,000 to $50,000. Don't move to Mississippi, by the way. The probate limit is $3,000. So if you have $75,000 or more, you will be subject to probate. But you see, a lot of my clients say, no, John, you're wrong. Because you see, when my lawyer drafted my will, he told me that I had everything in joint tenancy. And he said he would put everything in joint tenancy in one hand, and he would put everything in a will in another hand. And this is my estate plan. And you know what? They're right. This is the most common way that assets are held all over the country, in some form of joint tenancy and then in a will. In Arizona, we're a community property state. That's great, but community property is just another form of joint tenancy. Let's look at what this means. When you have community property or joint tenancy, especially if you're a couple, it means exactly what it says. It means that one of you owns 50% and the other one owns 50%. At the death of the first spouse in a community property state, there is no probate to the surviving spouse. But at the death of the second spouse, there's probate on the estate. So community property does not eliminate probate, but it does delay it until the death of the second spouse. So in this example, we need to understand this is very common. This is not wrong. Most assets are held this way all over the country, but we need to understand what it means to us when we start considering our estate plan. I've been talking to you about probate after you die. Were you aware that you can go through probate while you're alive? Have any of you ever heard of that? See, that doesn't surprise me. It's one of the dirty little secrets that you'll never hear. Just like you'll never hear that the will that you've been drafted doesn't take care of you at all while you're alive. Remember, a will says, when I die, all these things are going to happen, right? A will doesn't protect you while you're alive. It's not designed to do that. Why are they called living trusts? They protect protect us while we're alive. And that's important. Also, they never said that the house you have is enough to drag you through probate. They just forgot to mention that part. They also didn't say that it doesn't eliminate the problem that we have that we can go through probate while we're alive. And this is how it happens. We've had some beautiful weather recently. I mean, what could have been better than last night, Halloween? The kids were out in tank tops and short pants, and around the country there's snow flurries. So it's pretty exciting. So you decide that you and your spouse are going to go off for a walk this evening when it gets a little cooler. You're minding your own business. You live in beautiful circumstances. And some idiot comes flying down the street, runs you over. But you're not dead. You're also not competent. You're really hurt. You could have had a stroke, Alzheimer's. You're really hurt. A physician examines you and says that in their medical opinion, you or I, we can't sign anything. We cannot conduct our personal, professional, or financial affairs. And your spouse is told there's a special clinic over into the Mayo Clinic that can handle your husband's condition just fine. It's an hour and 20 minutes from here to the Mayo Clinic. It's a long drive on a good day. On a bad day, it's even worse. So you decide, I'm going to sell my house here and downsize and move over on the other side of Scottsdale near the Mayo Clinic so that your spouse can be properly and treated for the rest of their days. You decide to sell the house. You only own half the house. Your spouse owns the other half. Remember what I said. At the death of the first spouse, there is no probate. In my example, he's not dead. Guess where you're going? To the probate court. You're going to say, look, Your Honor, I got a big problem here. I have a letter here from my husband's physician, and he's been treating him, and he has a diagnosis that states that in his medical opinion, my husband cannot conduct his personal, professional, or financial affairs. He's not competent. And Your Honor, what I'd like to do is I'd like to break joint tenancy. I'd also like to break community property. I want to sign for his 50% because he can't, and I've got a letter here to prove it. Are they going to let you sign for his 50%? Of course they are. After they do a review of who holds title, after they find out how much you're worth, and they're not going to do it for free. You just went through probate while you're alive. Living probate is called conservatorship. We've heard that term, and we think it's for the uber wealthy. You know, the Kennedys and the Rockefellers, they have conservators. But you know what? It's also known as guardianship. We've heard that term. You want to grind your teeth to dust? You do what I've done. Sit in a conservatorship court for a week. Watch perfectly reasonable, hardworking, honest people try to become the guardian of a spouse, or maybe it's a child trying to become the guardian of their mom and dad. That's about a 45 to 60-day ordeal. It runs about $5,000 to have an attorney help you become the guardian of your parent or your loved one. And remember, the toughest estate planning to do is for people who have no children and people who have one child. Now that goes against the grain, doesn't it? We'd think, gee, what's the big deal? I've got one child. They're going to get everything. It's got to be easy, right? No, because we have to ask the horrible question. If your son or daughter dies before you, who's going to speak for you? Who's going to get your money? Who's going to speak for you when you can't speak for yourself? Because the problem is not if we die. It's if we don't die. You and I have had friends that have strokes, Alzheimer's. They're still alive, but they're not competent to do anything. And they end up in conservatorship and guardianship courts. So you and I can go through probate while we're alive. But you never hear about that because the family is either very upset that mom and dad didn't do anything prior to the problem, or they're too embarrassed. They don't want anyone to know. But you see, people still say, no, John, you're nuts. Because you see, when I had my will put together, I've got some great kids. And I love them. They've been raised right. And I've been told, just put your kids on your accounts. Put them on your checking account. Put them on the deed to your house. Put them on your savings account. Go down to your broker, put them on your brokerage account. Your money market account. You know, it does make sense. I can't tell you how many thousands of clients. My legal group has drafted over 28,000 trusts in Arizona. We know what we're doing. And most of those clients, they've been told by the credit union or the bank, just, gee, Billy's a great kid. Yeah, I see him in here all the time, Mildred. You ought to put him on your checking account because you know something could happen. Put him on your savings account too, and you know you have a safety deposit box here. And you know, that's not a bad idea. As we first think about it, that makes sense. Because with a couple, if something happens to you, who gets it? Your spouse. If something happens to your spouse, who gets it? You. And if something happens to both of you, who gets that asset? The child. In many cases with little or no probate. What a deal. Let's put our kids on all our accounts. Because we love our kids, we've raised them right. Now, we love all our kids. But we know which ones are the most responsible. And this is not the village idiot, okay? This isn't the kid that we've had problems with. This is the son or daughter that we know is going to do right by us, or they live here now. And for a bunch of reasons, this is a great idea. But this child is driving down the street one day, and they get in an accident. It's not even their fault, but they get sued. What do they own? What do they legally hold title to? Oh, no. That's my mom and dad's house. That's not my house. No. You gave them the legal title of 1/3 of your house, 1/3 of your checking account, 1/3 of your brokerage account. Oh, no. That's my mom and dad's CD. What if this child gets hurt in that accident? Now they're not competent to sign anything. You can't sell your house without the signature of all joint tenants. Now you're going to the probate court to get them off your accounts because they're not competent to sign. What if this child has a divorce? Did you really want to give 1/6 of your savings account to your ex-daughter-in-law? Everybody shake your head. No, I don't want to do that, okay? Not a good idea. What if this child has a bankruptcy? Oh, no. That's my mom and dad's money. That's not my money. No. Everything we do in estate planning goes back to title. Title. And we have to keep that in mind as we consider what we want to do and what our options are. So this is the challenge that we find ourselves in. The challenge that we find ourselves in is that the most typical estate plan involves a will in one hand and something in joint tenancy, and often with our kids on that asset. But I have to tell you, as common as this is a very dangerous way to hold assets. And we're not told anything about that because we're going to people whose business it is to make sure that they have a lifeline to us when we die. Your children and mine are programmed to go through probate. And what do I mean by that? You have your will. Here's your will. It says Stephen Stevens, attorney at law. Now, the odds are kind of against the men here. I just really appreciate that so many men are in attendance. Many times the men say, hey, I'm going to be the first to die. Honey, go ahead and take care of it when I'm dead. And so to have you all here today, I really tip my hat to you. It's a serious thing. But the tendency is that the men are the first to be ill or injured. The ladies tend to be the caregiver. That means that mother's the last to die. So now both parents have passed away. The children open up the will, and they call this guy Thompson to get him to say, my mother died, and I've got the death certificates. And they're going to say how sorry they are that both of the parents have passed. And they're going to say, for a $6,000 retainer, I can go ahead and get the probate started. It'll only take me a few months, and I've got a copy of the will in my file. You just kicked open the doors to probate court because your children were trying to honor you at your passing. We're all programmed to do that. We just assume everybody goes through probate. But I have a question for you. Does it take an attorney to sell your house when you die? Everybody shake your head. No, it doesn't. Yeah. Does it take an attorney to close a checking account when you die? No. Does it take an attorney to get on the phone and say, my mother had a life insurance policy with you. I just need you to send me the forms because she's passed away and I've got the death certificate. It doesn't take an attorney to go for any of those things. So why are we going through probate? Because we don't know we don't have to go through probate. We just assume everybody does. And so this scenario is so common. But what's the solution to this predicament that we're in? The solution to this predicament is this thing called a living trust, because we need to understand how they compare. With a will, remember, you're subject to probate law. Even if you die without a will, you're subject to probate law. Your will is a matter of public record. I don't know if you knew, but we could get in the car right now for $2. I can get a copy of all your neighbors' wills. It's none of my business, but I can do it, because under probate law, it's all a matter of public record. Contestable. About 30% of the wills that are contested are altered in favor of the person that contested the will. You were never told that, were you? You were never told that the will that you just signed and paid good money for had a 1 out of 3 chance of getting blown up after you die. And remember, you don't have to be a beneficiary or a relative to contest a will. A stranger on the street can put a lien on a house and hold it until they get what they want out of the estate. If you think it doesn't happen, sit in the bridge club sometime and listen to everybody's stories about what happened in their family when some stranger came out of the woodwork and said, he always said I could have his Jeep when he died because we went hunting together. And there's no record, no proof, so he puts a lien on the house. Now, is he going to win? Probably not. But the kids are going to say, just give him some money. Let's get past this. He's delayed the probate another 6 months. But did he win? Yeah, he did. He got some money, even though you and I would say logically he shouldn't. But it does happen. So it's easy to contest a will. Multiple probate. If you have assets that equal the probate limit in any state in which you live, you will go through multiple probate. We have a lot of snowbirds here in Arizona. They're fabulous folks, but they have not been told by their probate attorney they're going to go through probate twice. Because remember, probate law, the principle of probate, though it's the same in every state, the level of probate is different in every state. But trust law is not different in every state. Trust law is the same from coast to coast. And so we have clients who say, if I move back to Minnesota, to Oregon, to Washington, to Illinois, is my trust any good there? Do I have to do it all over again? No. All you have to make sure of is that you put your assets when you go back home for good into the trust. If you buy a new house, put it in the trust. If you go to a local little bank that you love that's in your new old community, tell them you have a trust and they'll put your accounts in the trust, because everything goes back to title. Conservatorship, we talked about that. That's living probate. You do not avoid that with a will. The delays are pretty serious, 6 months to 2 years as a minimum. The probate fees we talked about 4 to 11%. By the way, the national average for probate fees runs about 7 to 12%. So we have a lot of active retireds who pass here. And so the fees are a little bit lower in Arizona. It doesn't mean it's a good thing or that it's right. It just means we're a little bit more efficient. And the loss of control is tremendous. Remember that the problem is not if we die. It's if we don't die. With a trust, there is no probate. And with a trust, everything is private. Nobody can go downtown and get a copy of your trust. Because under trust law, the only one that gets a copy of your trust is who you give it to as trustee. Uncontestable. As I shared with you, as of last Christmas, we figured out that our legal group has drafted a little over 28,000 trusts in Arizona. That's important to clients. We're not writing our first trust using your estate and hoping it works. We have had thousands of clients have to use these documents at a critical moment. And let me tell you, the critical moment is not when you die. It's if you don't die. Please understand, when I first started doing this almost 30 years ago, I didn't have clients in their mid-90s who had children in their early 70s, who had grandchildren in their 40s, and had great-grandchildren in their teens. Now I've got clients in their mid-90s playing 3 rounds of golf every week. We're living longer and we're living healthier. But when we're ill and injured, we're living longer as well. And that's the challenge. Also, remember that because we are living longer, we have more blended families now than ever before, where clients are in their late 70s and 80s and they find another special someone. And their kids don't know anything about the other family. He's got 4 kids, she's got 2 kids. I shatter all the statistics, by the way. I lost my wife to colon cancer almost 15 years ago. She was 50 when she died. She died in bed next to me. We met when we were 13. We were married 30 years with 3 children. I know what it is to lose a spouse. Many of you in here do too. But I shatter the statistics because not only did I outlive my wife, but she died at such a young age. So I've been through what you've been through. And I know the importance of taking the time to do estate planning, not estate guessing. So, conservatorship, guardianship, but we've been doing this a long time. I've never heard of, let alone experienced, the successful contesting of a trust. Now, there's always a lawyer who say, give me $10,000 and we'll break this thing for you. It has never happened that we know of. If the trust is properly drafted, and a trust can be if it's done by a proper estate planning attorney, you don't have those issues. There's also no multiple probate. You could have 5 houses in 5 states and accounts all over the place. As long as you have them all in that trust, you will not go through probate in any of those states. There is no conservatorship and no guardianship because in a trust you choose who will be your guardian now. And there's a pecking order. So it's not just one person. We suggest no less than 2. And that's why it's hard for people who have no children, because they have to scratch their head and say, gee, who do I choose? Do I choose my younger brother? Do I choose my nieces, my nephews, or my best friend around the corner who's 10 years younger than I am? It's really hard. There are no delays. We've helped hundreds and hundreds and hundreds of our clients transfer their parents' trust estate to the kids in 1 day. I've done it myself in my own family. My father-in-law was 88 when he died. Great guy. Of course, I told you I met my first wife when I was 13. So I've known my father-in-law all my life. Graduate of MIT, wonderful guy. But the last 5 years of his life, he had 2 years of very serious dementia and 3 full years of full-blown Alzheimer's. He was in fabulous physical health. He could walk in here, play cards, tell you stories, but don't ask him his name. He didn't know. In fact, he would pull people aside whenever we came to see him. He lived over here behind the ballparks, right? Just not a half a mile from here with my brother-in-law. And he would say, nobody's feeding me. But he just got off the table and out ate everybody at the table. But he just didn't remember that. He was legally incompetent, but he was fabulously healthy and strong. We need to understand that's the problem that we go through, is living probate, being able to have your wishes honored before you need to have that happen because it'll be too late. Please understand. There are no delays. There's no settlement of probate fees, and there's no loss of control. But I have a question for you. It either works or it doesn't. We say, this is what happens to you if you have a will, but you don't have those problems if you have a trust. So my only question to this group is a simple one. Why? Why isn't there any probate with a trust? We keep talking about one word, don't we?
The trust holds title.
Ah, perfect. This is the trust I'm going to be delivering tomorrow. This is a real trust. Some of you have a trust. Most trusts, if you're single, they run about 8 documents to upwards of 11 documents. This is this client's new deed. You will not go through probate on your house because we draft a deed that takes it out of probate and puts it under the protection of your trust with you as trustees. These are the letters to the bank, the broker, the credit union, the life insurance company, the annuity company, telling them that you've established a trust and that you want them to retitle your existing accounts into your trust with you as the trustee. In that way, you're not subject to probate law. In this document, the way our attorneys designed this, we list all the assets. You know what you have, but your kids may not have an idea in the world. And you don't want them to have to go fishing for stuff, right? So the trust itself literally allows you to settle your estate now. You're the settler. In fact, you hold all the titles in the trust. Settler, trustee, beneficiary, testator, testatrix, representative, all those legal titles are all yours because you're in charge. But you're taking your assets, your pile on the table, out of probate law under the protection of trust law with you as the trustee. Now, let's say, God forbid, your spouse has a stroke. When my wife was on hospice care and morphine drip, she weighed 70 pounds. She was legally incompetent. She could not sign anything. But I didn't do anything to the trust because the trust already said if something like that ever happened, you're sitting next to a perfectly functioning trustee. The blink of an eye, it's taken care of. Now, what if, God forbid, one of you dies and the survivor has a stroke? In your trust, you choose someone that I call the secretary to your trust. They have no power to change your trust. In that scenario, as soon as the second trustee becomes incapacitated, the trust becomes unamendable and irrevocable. No one can change the trust. Even if they tried to, the banks, the credit unions, the brokers, they would never allow it. They know better. We call that person a successor trustee. They succeed you as the trustee in a trust. And our clients all the time say, well, that's like an executor in a will. No, it's not. An executor in a will is the one that gets dragged through probate. This person is not going to go through probate. This is the person that's going to sell the house, close the accounts, do a final tax return, and cut the checks. My mother passed away about 18 months ago now in California. She was 84 when she died. We concluded her entire estate in 4 days. No court costs, no legal fees, no delays, no probate. Now people say, well, yeah, you do this for a living. I wasn't the trustee. My brother Jerry was the trustee because he lived closest to my mother when she drafted the trust. I don't think he could spell the word trust. He never looked at it. He didn't know what it was. He just said, oh, this is something that John does, and he let mom and dad have it long before my dad died. My dad unfortunately passed away when he was only 66. So, but my mother and especially my brother, he didn't get dragged through any of this. He was shocked because he remembers when his father-in-law died. And 2.5 years later, they got out of probate and it cost $36,000 to get out of probate. And he just thought, oh man, mom's passed away. Now I'm right in the line of fire. He couldn't believe that he could walk into a bank, sign a form, call the life insurance. He couldn't believe how much easier it was with a trust. Now remember that this is a revocable living trust. You can add, delete, modify, change, make edits all during your lifetime. There are irrevocable trusts. And we suggest that clients don't often get into that arrangement because before the ink dries, you can't make a change to that trust without the permission in writing, notarized, of all your beneficiaries. So I constantly heard from probate attorneys, oh, this is irrevocable, it's not a big deal. We'll just put you into an irrevocable trust. And the client doesn't like the sound of it, so they don't proceed. I want you to be on that phone call. When these 3 children that you've sent maybe a copy of your trust to 5 years later, you call them again because you'd like to make a change to this irrevocable trust. Remember, the only reason why we do estate planning is because we want to determine who's going to get our money, right? And we want to determine who's going to speak for us, right? If we can't speak for ourselves. So if we're going to make serious changes to any document, a will or a trust, it's going to be who's going to get our money and who's going to speak for us. So we're going to call Billy in 5 years and say, hey, Bill, remember that stuff I sent to you? You can shred all that. In fact, we're going to send you some documents. We want your permission to make some changes to the trust. Why, Dad? What are you doing? Well, we're taking you out, okay? Just wanted your permission. Would it be all right? That is never going to happen. So don't let anybody tell you that an irrevocable trust is the way to go up front. Now, in what scenario would we consider? Let's look at the blended family. In my scenario, he has 4 kids, she has 2 kids. They've married in their mid-70s. They were married 15 years, and now they've said, we've commingled some assets. She's got some assets, I've got some assets. We're going to do a trust that while we're alive is totally revocable and amendable. But at the death of the first spouse, the trust becomes unamendable and irrevocable. That means that the surviving spouse can do what you and I did when we were growing up. I can't do that. My mother would kill me, right? That's what we always say, blame it on mom, right? They can say, look, while both of us were alive and well, We can make any changes we want to, but we agreed that if one of us died, the trust could not be changed. That stops the surviving parent from being put upon by their children. And if you think that doesn't happen, I have a client here who lives in Sun City who went through that very same scenario. Her children and grandchildren live in Glendale. She has not seen them in almost 13 years because they told her, if you don't change the trust and give all the money to us, well, we never even knew him, you're not going to see your grandkids. And if you think that's rare, you need to follow me around for a year and listen to the type of pressure that's put on some parents, especially with blended families. I have a blended family. I remarried. She has 3 children, I have 3 children. I was 51 when I remarried. So I'm going to be around a long time. I know what it is to have a blended family. And we make sure we are sensitive to families that are in that circumstance as we sit down with them and talk to them about options. So please be aware that this would be a scenario in which an irrevocable trust would occur at the death of the second spouse. But don't take it lightly to say, I'm going to draft this trust and I'm going to make it irrevocable. You know the players better than anybody, and we're happy to make sure your wishes are honored. But be very careful when you consider an irrevocable document. Now, any properly drafted trust should have your living wills in it, which says that you and I don't want to be artificially kept alive. It should have medical powers of attorney, so that if you can't speak for yourself, you've chosen someone who's standing in the room who can make sure your wishes are honored. It should have durable powers of attorney for financial matters, which empowers someone to pay the bills and do things like that if you are infirmed. It should have a community property agreement if you're married, because we're a community property state, and there are issues with that we can talk about one-on-one. Of course, it should have his trust document itself and a certificate of trust, which is a mini version of your trust with all the private stuff taken out of it. And you should know up front what your trust is going to cost you. So, little checklist. If a person interrogates you, wants to know all the money that you have, please leave. They don't need to know that to do good estate planning. It's none of my business. It shouldn't be any of their business. That's the first thing. Second thing, they should be able to tell you what the cost of the trust will be. If they've done enough trusts, they know how much work goes into a trust. Don't let them tell you, well, we're not really sure. Don't let them charge you by the hour. They'll talk to you about their fishing trip and their dogs, and you're paying cha-ching, you don't need that, okay? They should be willing to come to your home privately and not charge you any extra for that. You shouldn't have to go back and forth and bring your parent, because when they do that, they charge you by the hour. And that's not a good thing. You should not be charged according to how much money you have. And you should know exactly up front, before you consider anything, exactly what the trust is going to cost, so there are no hidden issues. They should also make sure that they do the deed work for your house and do all of the retitling work for all your assets. I don't mean, we have a bunch of form letters in the back of your trust, and don't forget to put everything in the trust. What does that mean? If you do this wrong, you'll go through probate even though you have a trust. So we walk away from clients who say, no, I'll do that, because they've gone to a seminar where they're charged $150 a deed and $50 a letter. So they figure, I'll wing it, I'll do it myself. No. That's like the plumber coming up to you and handing you the wrench at the front door and saying, if you just turn it this way, it'll work, and I'll be out in the truck writing up the invoice. No. You're there to have him use the wrench. You paid them to do your trust. They should do this as a normal course, and it should be complete, and they should be able to demonstrate to you, because this client is not only we're going to go through this again when I notarize and deliver their documents, but we're going to sign all those letters. They know what's going in the trust, and they're going to be able to initial, and then there's the date transfer. When things start coming back, they have proof that these assets were outbound, that they signed the letters, and that they came back. Also, this trust has a gifting section in it. What if you want to leave your opal ring to your granddaughter or your stamp collection to your grandson? Many of my competitors will make you give them your gifting now. They'll put it in the body of the trust. And then if you find out a year later your granddaughter has an opal ring and she didn't need 2 of them, You have to call them and they charge you $120 to $150 for trust administration. Why? Under trust law, you're empowered to do gifting. You can draw a line through this, initial it, and it's out. Also, you will spend your whole lifetime putting things in and out of your estate. We all do. This is how you do that in this trust, the way our attorneys draft it. It says changes to the schedule of trust assets, property disposed of and property acquired. So let's say you get mad at your bank 3 years from now. We've already drafted a trust, or you've had someone else draft a trust for you that you were comfortable with. And then 3 years from now, you get mad at your bank and you say, give me my money, I'm going across the street to the other bank. You walk into the new bank and you say, I need a checking account and a savings account, maybe a safety deposit box. And by the way, I have a trust. And they're going to say, well, we need a copy of your trust. And that's why we have here a certificate of trust. This is a mini version of your trust with all the private stuff taken out of it. This is the only document in this entire book in this tiny type. See how all of this is much more readable and large and so forth? Why is that? Because this doesn't have anything private in it. It's none of the bank's business who you're giving your money to. This tells the bank the bare minimum they need to make sure your assets go into a trust. And then, right in this document, you just write property disposed of was my old bank accounts, property acquired was my new ones. They'll put it in the trust.
Does that go if you buy a new vehicle as well? So you can get a title? Do they need that as well?
That's a great question because remember, it goes back to title. If you go on to the dealership and say, I want the red one, here's a check, then you own it. And you would bring a copy of your certificate of trust to the dealership. And because they always ask us, who do you want it? And say, here, I have a trust. And they'll put it in the trust. But if you say, I want the red one and I want to lease it, I want to make monthly payments, technically we don't own it and we can't put it in the trust yet. So if you own clear title to boats, trucks, trailers, motorhome, golf carts, whatever it is, we suggest that you put everything in the trust. When in doubt, put it in the trust. Don't talk yourself out of doing it. Talk yourself into doing it. Yes, ma'am.
My grandmother just passed away.
Oh, I'm sorry.
And in fact, I'm going down to Tucson today to work with her trust. And she's got a list of items that over the years she has
Wanted to
dated and gifted.
That's great.
And who has gotten it, and she'll initial it.
That's right.
But she didn't have her car.
Doesn't matter. And because it's her car.
Okay, and you don't have to go, even though it wasn't in the trust, you don't have to wait for anything, it's still...
Well, remember, that's a great question. Every trust has what's called a pour-over will in it.
Okay.
A pour-over will is legally called a last will and testament. Now, all of you are looking at me and saying, wait a minute, you just told me how rotten wills are, and now you got a will in my trust. Are you crazy? No, this is very different than the will that your neighbors have because it's associated with a trust. This will is called a pour-over will, and this is the way it works. This will says, in this case, I live in Maricopa County, I'm married, I got some kids, but I have a trust agreement. And let's say at the time of our death, the bank or the credit union just made a mistake and they kicked our checking account out of the trust. You didn't do it, I didn't do it. They just made a mistake. Anybody can make a mistake, right? But we have a problem. We have a problem because if you have enough little accounts that are left outside the trust, if they rise to the level of probate, which is how much? $75,000, you'll go through probate even though you have a trust. But wait a minute, you have a pour-over will. And if those assets are at $75,000 or less, your kids are not going to get that money. Instead, that money is going to be poured over where? Into the trust. Can the trust own things? Everybody shake your head, yes. And in this trust, there's two beneficiaries. They get 50-50. Everything that's owned by the trust is going to be distributed. So the pour-over will is a safety valve that protects you and I in case the credit union messes up or the bank. So in terms of the car, if they've forgotten, we don't often have cars that are worth $75,000, see? So it would automatically just be poured into the trust, you see, and it would still avoid probate. But let's be careful about that. Your question is so important for this reason. I just did a trust for a farmer in Glendale. He's got 2 flatbed trucks, 2 tractors, 3 pickup trucks. He's got a golf cart. He's going to go through probate on his vehicles because he owns everything. He's a farmer. And his name was Bill. And I said, Billy, you've got to put all these things in the trust. I don't want to. I might sell that truck. No, the problem is not if you die. It's if you don't die. All that stuff is in your name because he was single. His wife had died. You're the only one that can, you're going to end up putting your kids in a huge mess. Put it in the trust. And then if heaven forbid you get hurt, or if you just want to sell it, you just sell it. You sell it the same way you would any other asset.
So if it's in the trust,
Yes.
the gifts are listed in the, when do we have to do anything, or as soon as we want, we can distribute?
In the documents that we provide, we give clients an overview that says what to do when a loved one dies.
Okay.
And so the first thing you're going to do, because we're pretty different than other trust providers, we'll come to your home. We don't care if you call us every week of your life. You're not going to get a bill in the mail. We never do that. We do trust reviews for clients on site. Even if we didn't write the trust, there are no fees for that. I just met with a client who lost her husband, and her 2 daughters came into town because they're worried about mom. They flew in for her birthday. They surprised her last Thursday. I met with her on Friday. The client called me out of the blue on Thursday night and said, my daughters came for my birthday. Of course, they're really worried because Dad just died about 6 weeks before. I met with them. We went through all trust. We did a trust review, answered their questions. The first question they asked us is, how much do we owe you? You've been here for an hour and a half. And we said, nothing. That's called customer service. That's what we do. So be careful when you speak with a trust provider or a probate attorney that you know that if you pick up the phone and call them, is it going to be $150? And so in this case, though, I can get you a copy of this, What to Do When a Loved One Dies, and you can use that as a stepping stone when you go down to Tucson. Okay? Great. Excuse me. Go ahead. I'm sorry.
If your vehicles are worth over $75,000,
Yep.
Is it only them that go through probate, or does your entire trust?
No, it's only them. It's only the asset.
So it's only the assets that are
That's
outside
right.
the trust.
And see, your question's an excellent one. I had a client call me, it wasn't a client, it was the daughter of a client about 3 weeks ago. Her mother had died. And we did her trust about 15 years ago. She lived in Gold Canyon on the other side of the valley, but when her husband died, her daughter lived here in Surprise. So she said, why should I live across the valley? Because he liked to golf and there was that was it. But she didn't want that. She wanted to be close to the grandkids. So she moved all the way across town and bought a townhouse, downsized and didn't need a big house on the golf course and so forth. About 4 years later, she died. 4 or 5 months into this, the daughter calls me and says, we're going through probate on my mom's house. Why didn't you put it in the trust? I said, we did put it in the trust. We have proof that not only did we draft the deed, but on the day that we delivered the trust, we listed all the assets, and that says personal residence right there. Why? She said, well, no, my mother moved. And I said, well, she never told us she moved. And she never told the people that she bought the house from, because she paid cash for it, I have a trust. Here's my certificate of trust. So they left it outside the trust. So she did not go through probate on any of her other assets, but she went through probate on the house. And please understand, just the filing fees and the time that it takes to just take one asset, in this case, a house, that's about a $5,000 to $6,000 probate bill. It takes about 6 to 8 months as a minimum. So when in doubt, put it in the trust. When we deliver a trust, we tell every client, the only thing you need to remember from this day forward is, I have a trust. If you buy something, if you mix something, if you change something, you could buy a new cabin in 3 years. Just tell the real estate agent, hey, we love the place, we're going to buy it, and by the way, we have a trust. Here's a copy of my certificate of trust. Yes, sir.
If you have a living trust, should you have it reviewed every so often for changes during the trust law?
I wish I could carry you around with me and have you say that to everybody we speak to. We suggest that our clients call us about every 3 years, and we come out to their home or to their broker's office or to their place of business, and we do what's called a trust review, and there are no fees for that from us. And so if you have an old trust that hasn't been reviewed in a while, please get in touch with Bob or Matthew or myself, because we'd like to help you with that if that's something that you'd like to do.
What about if your original trust was in another state?
It doesn't matter. Remember, trusts are good all over
Yeah,
the country.
I know,
And just because we do a trust review, we're not trust peddlers. Just because you have a trust review doesn't necessarily mean you're going to have to change your trust. There are lots of right ways to do it. By the way, when we do a trust just like this trust is $1,295 total. Total. $1,295 total. You pay for about $450 usually up front. 95% of the trusts that we provide are $1,295. If you have a special needs child, if you have an estate that's a little bit larger and you might need an AB trust, if you decide one of my children is on drugs and I can't give them a third of the estate because if I give him a bag of money when I die, he'll kill himself. So I want to have his third held in my trust for a period of 5 years after I die. And he has to pass a drug test before he can get the check because his sister's the trustee. That's a trust within a trust. That's called a subtrust. They usually call it, it's just legal time, but it's usually $200 to $300 depending on the involvement. But that's not very common. Yes, sir.
Yeah, that brings up the point. We have 2 children.
Yes, sir.
A daughter and a son. The daughter has MS, so when we drew our trust in '79,
Yeah.
when we both passed on, we were going to have our son take care of her portion.
But did you draft a special needs trust?
Yes, we did.
Okay, but that's
And so
changed
just as soon
significantly.
as we did that and gave both kids a copy.
Yeah.
The daughter called and said, I don't want my brother to be in charge of my part of the trust. I want my husband.
But what if her husband dies before you?
Well, then it drops down to our.
That's all I'm saying is that we hope for the best
Yeah,
and we
it drops
plan
down
for
to
the
our
worst.
grandson.
When you will go to sell a property that's titled in the trust, can you sell it in that title or do you have to take it out?
Great question. Let's use the scenario that I don't have a trust and you do. And you did a trust with us 10 years ago and we put your house in the trust and now you're selling it. I am the buyer. I would go to the title company and sign paper as a buyer. You would go to the title company and sign papers as a seller. But one of the things that I would sign that you would not sign is a new deed, putting it into my name. Because remember, my example, I don't have a trust, and of course I do. So it's the exact same process whether you have a trust or not. The beauty of it is, though, if heaven forbid you've had a stroke, it's in the name of the trust. Your children can say the doctor wants mom to go in a facility and I need to sell the house to pay for part of her care. As the secretary of the trust, they can sell the house in her behalf because, remember, not one physician but 2 have personally examined mom and determined in writing that she's not competent. That triggers the powers of attorney, which allow them to sell the house. So we are not doing estate guessing here. We're doing estate planning. We want to know that we've chosen people to make our medical decisions if we can't. We've chosen people to make our financial decisions if we can't. And remember, it's your money. It's not their money. No disrespect to your kids, but it's not their money. I will tell you that this year we've probably written, what, Matt, Bob, probably 60 deeds for clients who refinance their houses. And they're existing clients. They call me, oh man, I refinanced the house. They took it out of the trust, but they never put it back in. And so thank heaven, we say, well, send us a copy of the deed. And so with very minor circumstances, there might be $100, $200 difference, but I will tell you that 95% of the trust that we provide. My personal feeling is, if you can't be told what the trust will cost, you need to leave politely, but leave. If they want to know all the money that you have, you need to leave. If they're not willing to tell you that they're going to do the retitling and not just leave it up to you, you need to leave. And if they should be willing to answer questions from time to time at no cost to you, because you don't want to create this never-ending story, because many of these entities don't do that. I can't thank you enough for coming. Thank you so much for coming. That's what we wanted to share with you today. We hope you've learned something that you didn't know, and we're here afterward to answer any questions you might have.